Hello, welcome to Legalese. Legalese is a half-hour presentation of the Northern Middlesex Bar Association. It's designed to bring topics that we hope would be of interest to the public, to you, so for your education, edification. I'm joined today by Attorney David Erickson from Acton. Attorney Erickson, thank you for joining us today.
Thank you for having me.
And Attorney Erickson is an expert in the area of law dealing with the Sex Offender Registry Board, and that's the topic of today's program, the Sex Offender Registry Board. The Sex Offender Registry Act was passed, I believe, in 1996 originally in Massachusetts. And according to language from one of the cases that was promulgated under that law, it was founded to protect the public from the danger of recidivism posed by sex offenders and to aid law enforcement officials in the apprehension of sex offenders by providing them with the additional information critical to preventing sexual victimization and to resolving incidents involving sexual abuse and exploitation. Fancy language for the purpose behind the Sex Offender Registry Act and thus the Sex Offender Registry Board. What is the Sex Offender Registry Board?
The Sex Offender Registry Board is a agency of the government of Massachusetts. It's a board that's appointed by the governor. There are also hearing officers and other agency personnel that are in charge of determining whether somebody should be classified, and once they're classified, providing that information to the public. The most well-known part of the board is the fact that some convicted sex offenders are given levels of dangerousness and recidivism, and that information is published to the public for level 2 and 3 offenders at this point.
Okay. How many persons sit on the board?
The board varies from time to time in its number. It's typically five members. Mm-hmm. They sit for a term of years, but they also are responsible for appointing other people called hearing officers that actively decide the case, but they have the ultimate responsibility for overseeing the law.
Okay. Well, let's get into the actual classification of individuals and the registration that persons who have been convicted of certain crimes have to undergo. Can you tell us about that?
Sure. When an individual is convicted of a sex crime, and they're delineated by the statute, certain crimes, very clearly apply, and others there's more discretion in whether or not the person has to register. Once they're convicted after a plea or a trial, they're required by law to register in the state, and that starts a process whereby a classification of them in terms of dangerousness and recidivism takes place.
What is the classifications that are up for grabs, so to speak?
There really are three, although when you look at it more fully, there are probably two more. One, a person could not be ordered to be registered, and they have to show no dangerousness and no recidivism risk. And it's not a 0% chance, but it's basically very, very low, because there's a requirement that the person is coming to the board and the public and saying, I'm a sex offender, and that's a summary of language from a state Supreme Court case. And then we actually do have part of our statute that designates somebody as a sexually violent predator, or language to that effect, but because the requirements of giving that classification are so high, that's rarely used. And so there are really three levels. Level 1, a low level of dangerousness and recidivism. Those people aren't put on the information isn't available to the public. They're not put on the internet. Level 2, a moderate or medium risk of dangerousness and recidivism. Those people now are on the internet, but a few years ago, they were not required to be on the internet. And if they were classified before, they're not on the internet right now. Although that information is available if a person were to go to their local police department and request the names, the identities of registered sex offenders. And then level 3, those are the highest level of dangerousness and recidivism. And there is generally an active effort on the part of the local police department where the offender registers to notify the public of the existence of those offenders.
So the difference between level 2 and level 3, they're still posted on the internet? In both cases?
They are on the internet, but with a level 2, it's thought that there's a moderate degree or medium degree of dangerousness and recidivism. And with a level 3, there's a higher level of dangerousness and recidivism risk. Mm-hmm. And so that the person has either accepted that designation or after a appeal through the board's system has been given that designation.
How does the designation come about? How is it determined that a person would be a level 1 low, level 2 moderate, or level 3 high?
It's actually a fairly a complicated proceeding. It begins when the person essentially communicates with the board and is given a opportunity to provide information to the board that the board considers in assessing their risk. At the same time, the board makes an inquiry through law enforcement to gather certain information about the person, and it's sort of what you'd logically think the board would look for: the criminal history, the nationwide criminal history, the police reports, anything that they can lawfully gather about the person. And then,
where's that information come from? The local police department, the
court? It
court?
comes from the local police departments. It comes from the criminal offender board, the agency that's in charge of keeping criminal records. It comes from federal law enforcement organizations. It's, the ability to access it is limited to law enforcement generally, although there are exceptions, of course.
Right.
And that information is gathered. It and the information provided by the offender are considered by an analyst with the board, and a level of risk is assigned. The offender is given the notice of what that risk level is, and then they have a right to either accept it, say that, I agree that that's my level of risk, or they can request that there be a hearing before the board.
So one analyst is making the original determination?
Well, there's an analyst that gathers the information, and generally there's a board member who's assigning, and there are specific requirements about how that's done, but generally that's the rule, that there is a board member making that determination.
Okay.
And the board members are picked by virtue of their experience, education, training, and experience, and there is a statute that requires who can be a board member.
Now, you said the options being 1, 2, or 3, but there being the other option of not even being determined to be a sex offender?
Well, there are, I think the most common example is, there are instances where people have, we do not have some statutes which, we don't have a public urination statute that those people who are charged with certain crimes are thought not to, the crimes aren't really thought to be sexually dangerous, and so those people might come to the board's attention, but they'd be removed from consideration. At the same time, a person can have had a sex offense 15, 20, 25 years ago. They can in fact have moved down the level of classification and ultimately want to be terminated from registration.
Okay.
And so they also are, although they might have one time been a 1, 2, or 3, they eventually can request reclassification, that is lowered in terms of their level, or terminated from registration.
All right, before we get into reclassification, let's talk about the person now having gone through the analyst phase.
Right.
They received that letter that says, we believe you to be a level 1, a level 2, or a level 3. That person, that recipient, looks at the letter and says, I don't like what they're saying here. What's their recourse?
They have a right to file, they have a right to file multiple appeals, but the first appeal would be to the board itself.
Mm-hmm.
And I'm somewhat summarizing the procedure now, but basically that they would come before a board member or an individual appointed by the board to hold a hearing. And this is a little different than either a civil or a criminal trial. These are technically civil proceedings, but the evidence is more somewhat more relaxed, and the government has the burden to demonstrate a level of risk,
Mm-hmm.
and then the potential registrant has a right to contradict that proof put forth by the board. And the board does have a board prosecutor, so there's a hearing officer or a board member, and then there's a board prosecutor. And that's typical of most agency matters, that there's an arm of the agency that's prosecuting the person or prosecuting the case, and then there's the agency itself is making the decision.
Mm-hmm.
And then the person can call an expert witness, somebody who, generally a psychologist or a psychiatrist who has an expert in assessing risk in this area. They can call friends and family members, essentially anyone who can demonstrate a lower level of risk and dangerousness. And then there are regulations that the board also looks to in deciding these cases. So there's a statute, and then there are these regulations. And then the hearing officer or board member makes a decision, and then if the person does not like the decision, they can appeal into the superior court. And then if they don't like that decision, they can appeal from there into our appellate courts. And there are actually, a number of cases that, have considered these issues. Recently, our state Supreme Court handed down a decision that really drastically changed the landscape of what goes on in these cases.
Now, in these cases, you mean within these hearings?
Within these hearings and within, the registration process.
Now you said that there's a relaxed evidentiary standard, or?
Well, the board takes, you're allowed to introduce evidence which is relevant, and
Mm-hmm.
some of the typical hearsay rules and some of the requirements of evidence that in a civil or criminal case would be very strict are more relaxed. Now, recently our state Supreme Court has raised the standard of proof that's required from, it used to be a fair preponderance of the evidence, meaning more likely than not, to clear and convincing evidence, which is a much higher burden.
Sure. And that was based on due process grounds.
That was based on a due process ground, and among the points the state Supreme Court looked to is that the prosecution of these, these are thought to be serious offenses, registration and failing to register. They have impact on, where one can live, work. It has a tremendous effect, and it is in the, tens of thousands, I believe, of individuals in the Commonwealth who have to register.
Mm-hmm.
It's consistent with a framework established by our federal government,
Mm-hmm.
and that's why and now level 2s are on the internet. That's changed from when this, this statute was first enacted. And there's a heightened level of due process required.
Now, you sent me a copy of this case, and one of the things that struck me in that case was how the court was looking at the way sex offenders are being treated under the law from when the law was originally passed in 1996 to I think was the most recent was perhaps in 2013. How now people are undergoing more stringent requirements, but also that there are certain things that are illegal that weren't illegal back then, that are predicated upon the sex offender designation. Correct?
Right. Even one's legally required once one's classified to register, and the punishments for failing to register have become greater if one doesn't register.
Mm-hmm.
The fact that level 2s are on the internet has a dramatic impact on people. And I think there's also generally been an appreciation by our courts that these statutes, just by their very nature, have a tremendous impact on people in terms of where they live and work, as I said a moment ago, and that correspondingly the burden should be greater on the government to demonstrate that this is necessary to have these people register, and that the board should be clear in its decision.
And by raising the burden, I guess they were saying that it's more important that we get it right than that the risk of error now can hurt the potential registrant more than it can hurt the Commonwealth. I think is how they
true. It is the public policy behind the statute, though, is in part to, of course, protect the public. One of the we haven't mentioned it, but there is, generally lawyers are involved in these proceedings. I'm contacted by people that just have received the initial classification letter, and you have to help them gather the information that lets the board fairly decide the case.
Mm-hmm.
And naturally at the hearing, an attorney is involved, and additionally if somebody's indigent, if they can't afford an attorney, there's a panel of attorneys with the Committee for Public Counsel Services, which is our public defender's office that provides services to indigent individuals that have to register. Often also it's part of something that's being considered when a criminal defense attorney is resolving a case that involves a sex allegation.
Sure. Now let's move to the topic that you had raised earlier, and that is reclassification. How does reclassification occur, and how does it come about?
Reclassification is not automatic. It's not essentially once somebody is classified, they hold that classification. Some offenders do expire after, I believe it's 20 years. But
what do you mean they expire?
Well, certain statutes, by virtue of the passage of time, you'd lapse from registration. But many, and this is kind of a fine point, but many individuals are convicted of crimes that there is a view that it's stated that they have to register for life. But there are constitutional claims that can be brought that where the person does not have a recognizable level of risk or dangerousness, they should not be required constitutionally to to register, and it should not exist, should not exist under the framework of the statute. The board does always state that they're required to register, and those cases actually do have to make their way into at least the Superior Court for there to be relief from the registration requirement. But if somebody determines they've registered for what they believe is long enough, or what they would argue is long enough, and typically you often do this with an attorney, but you're not required to. Mm-hmm. There is now a part of the regulations which sets forth what a registrant has to do. They have to supply an affidavit with certain information. They have to supply the same background information. And the board will hold a hearing. These hearings typically now have, instead of one person, they have 3 people who decide the case, and they essentially redetermine the level of risk. Right now, there is a fairly long backlog, and so it's something that if you want to do, you should, kind of start early.
Now, you begin that process at the board stage?
You begin that process with the board, yes.
And they'll either agree with you or deny.
Well,
and if they deny, what are you looking at that point? Is that when you go into the Superior Court?
They at that point, typically now you end up with a sort of an automatic hearing.
Okay.
And some of the hearings, I will be honest, are more rigorous than others.
Okay.
Meaning that they're, the odd thing about the board proceeding at that point is the board prosecutor has dropped out. And so it's essentially the person trying to get reclassification or termination and the board, and it's 3 members, and you present, the initial evidence is represented sort of automatically, and then you present your case, which often, includes the same type of information, an expert, friends, family, those that would demonstrate either a decreased or absence of dangerousness and recidivism risk. And then the board enters a decision. The board has, in my experience, at that point, entered a decision that they discern no level of danger or risk, but the person is required to register for life. And so they say the person has to remain at a level 1. Then you would have to appeal into the Superior Court to argue a constitutional claim.
Okay.
And the Superior Court has generally been receptive to those types of claims. With the more, I'll call it garden variety, level 3 offenders, they can reduce them to a level 2 or a level 1. And again, after the passage of a long period of time without any recurrence and a stable lifestyle, and I know that we read so much in the paper about the dangerousness of offenders, and clearly there are offenders that they go on and they live very normal lives, much like any criminal may commit a major crime and then reform themselves. Mm-hmm. Again, there's with the other types of reductions, there's an appeal from that as well.
And where does that appeal go to?
That appeal also goes to the Superior Court and through our appellate court system.
Okay. David, I want to thank you for joining us
It's
here
been,
today. I think it's an area that I think a lot of people have heard about, but certainly a lot of people aren't aware of how it operates, and I appreciate your bringing your level of expertise here today.
well, it's an important law that does provide protection to the public, but it's a very, very serious issue, and it's really much like any of our laws that we have rights and protections that all of us have, and we live by the rule of law, and it's just part of a complex scheme that's designed to protect the public.
Right, right. Well, again, I thank you, and I want to thank you all for watching again today. As I tell you at the end of every program, anything that you've heard today should not be taken as advice in by any means as to anything that might be that you or loved one is going through. I would caution you that specific fact patterns can really change how things are applied. So it's very important that you talk to local counsel, someone such as David, who brings expertise to a particular situation, and that's what local counsel is there for, and their experience can be invaluable. David, thank you, and thank you all. And this has been Legalese, the Sex Offender Registry Board. Thank you.